Okay. Just a couple of announcements, same as I gave to the Monday group. Yep. Tutorials obviously have started this week. I know most of you, or some of you will have been already, and some of you might have listened to the recording from Monday about what I said about that. You have to handwrite the tutorial work, so I'm just re-going over some of what I did in the first lecture with you. You have to handwrite the tutorial work, has to be about 2 pages, and then you take a copy of that handwritten work and you keep the original and you give your tutor the copy. So I know there's been variations of that this week, but basically from the second tutorial on, or at least all of you who are going to next week's tutes, try to do that. So, handwritten, keep the original, give the copy to the tutor at the beginning of class, just leave it on the front desk, and that's basically how it'll happen. And of course there are the 5 tutorials and you get 2% for each one. The turnouts have been pretty good so far this week. I think in my Monday class I probably had about 40 students turn up. So there were still 5 to 10 students who didn't, but that's pretty good for the first week. Try to go to those because 10% is quite a lot of your grade, as I said, in week 1. Check your class number. A couple of students, when I've been entering the grades, have been in the wrong class, so I think they might be enrolled next week but have turned up this week. Be aware of that. With the other tutors, they don't necessarily have access to if you're in a totally different tutorial stream, they won't have access to the grades in that tutorial stream. So just be aware of that with giving them the 2% marks. It's the mock exam this week. Some of you will have done it already, some of you won't have. If you are in the tutes next week, my advice to you is, as I said in week 1, do as much study in chapters 1 to 4 as you possibly can, and use that mock exam as a good mid-semester study tool for you. Although they're not the same questions and they're not published on Blackboard, your tutors give you feedback on the areas and types of things that you should be looking at for the mid-semester exam. So it's a good sort of clue as to what could potentially come up when you sit that exam. I do have quite similar types of questions. So although they won't be the same, the things that you should know in those tutorial practice questions should sort of convert over to what you do in your multi-choice one. Eka public holiday. Anyone in the tute next Wednesday, you can go to any of them. So I've made this announcement on Blackboard, but if you are in one of those tutes, just pick any of the tutorials this week or next week, and you can attend any of those and get your 2% marks. Mid-semester exam dates out. It's good we've got the first mid-semester exam date, so we've got the 31st of August. It's 11:30 a.m. 31st of August is about 3 weeks away, so it's Saturday in 3 weeks. You do need to start studying. As you'll see in the tutorials this week, there are questions, although they're a little bit easier, there are questions from the book that we haven't covered in lectures, so you do start to need to read the book and look at those bigger sort of picture things that are covered in the book. 25 questions, chapters 1 to 4. For those of you who haven't listened to my Monday recordings, please note down these pages, in particular from the textbook. Pages 129 to 142. So 129 to 142. And pages 154 to 169. So roughly 30 pages total there. They will not be assessed in the mid-semester exam. So the content on those pages from chapter 4 will not be in the mid-semester exam. I'm not saying that you shouldn't read them, because in some parts they do talk about ILAC and different stuff that we're looking at today, but for the purpose of the mid-semester and reading over chapters 1 to 4 continuously, you don't have to concentrate on those 30 pages, okay? Summaries. Lots of students have been coming to see me, which is good. I've had to cancel a couple of appointments today that I'm seeing next week. Sorry about that, but I've just had meeting after meeting today. And a couple of students have already been to show me their work for their for their summaries, which is really, really excellent. And they're already up to date and started some of the stuff for next week as well. So that's very enthusiastic and good. As of this week is when you really need to start. So there's two schools of thought amongst students as to whether they summarise their notes for the mid-sem. Some students don't, some students do. Most students say to me, those are the ones who do, say they study better that way. So by typing it out and summarising notes, they remember things, which I guess is absolutely true. But remember, the mid-semester exam isn't open book. So what you do on summaries and what you do put into summaries you can't take in with you. Final exam is open book. So everything from this week on, when we start to look at negligence and torts, like I've got up there, all of this material, if you put it into one document, which a lot of you have been coming to look at in my office, it's going to make things a lot easier. I don't think there's been one student so far who's come to see me who hasn't thought, after I've given them the spiel and shown them what to do, it's a pretty good idea, not a pretty good idea to do what I suggest, which is a summary note. So do come and pop up at some point, do have a look at them, see how it's done, and it should be fairly beneficial for you. Don't get behind, for goodness sake, this is the start of it. It's week 3, you don't want to get to week 6 and not having started if you intend to. Just chip away each week, little bit, and by the end of the semester you won't have all that much to do in the SWOT vac because all your notes will already be done. And there's nothing to memorise at the end of the semester in this course, so if you've done the work throughout, very little to actually do at the end, which is a big benefit. Yeah, please do those. As I said, there's a high percentage of students who are, so it's a really good technique. The other thing I'd like to point out to you guys is just waylaying a little bit of confusion that's creeping in. Under the Teaching Week 3 material, so obviously if you go here on Blackboard, Teaching Week 3, which we're in at the moment, the tutorial exercise for this week and next are those questions. So that's what you have to prepare on your 2 pages of a response that you hand in. Some students have been emailing me saying, is this folder? So if you go to the non-assessable practice question, is this the one we have to answer for next week and this week? Answer is absolutely not. This is totally optional. I've put this up because it was the negligence problem from last semester. So students in Laws 1100 in semester 1 got to the final exam and that's what they had to answer for their negligence question. Really nice, simple one. Person driving a car, not really watching where they're going, runs over someone, causes injury. What's the outcome? This is totally up to you as to whether you answer it. If I was a student, I would not answer it yet. I would wait till next week. And after the lecture next week, when we look at the rest of negligence, so the requirement 3 and the defences, I'd then go home and before the following week's lecture, attempt that. Give it a go. Use the ILAC technique that I'm going to talk to you about this lecture and see if you can come up with a response. In Teaching Week 5 in the lecture here, I'm then going to go through with you the answer to this. So I'm going to put it up here. I've developed a PowerPoint similar to what I do in Tutes, and it'll be sort of like a working problem. So we'll go through the answer from duty of care, breach, and all the way through. Your best method of learning from that is having attempted it. So not by watching me do it. You do it first. It'll take you all of half an hour. You do it first, you try it, open book, use your notes, even dot point just ideas on what you think it is if you want to do something minimal, and come to class and see how accurate you are. You pretty much know at the end of semester you're going to get one of these. So I'm pretty open in the fact that most semesters, if you look at the past exams, I put up a negligence problem of some sort. So you know you're going to be assessed on this, you know it's going to be there. The more practice you get on it, that's 15% of the grade in the final exam. And if you're very efficient at it, at a negligence problem, you can save yourself a bit of time and then put it towards other questions that might be a little more difficult or you might be more challenging for you. So I've had students, really good students, who have timed themselves on practice negligence problems, got it down to about 25 minutes that they know they can do it in. They have their summary notes, they know what they're going to write in there, they whip it out in 25 minutes, and that's an extra 15 minutes that you have somewhere else. Because technically it's about 40 minutes per question in the final. So that's kind of how they do it. So that's just there for your own benefit. There's going to be a PowerPoint slide put up about it in the lectures. It's not going to be downloaded onto Blackboard because I want it a bit novel each semester, but you're going to see it and you're going to be able to look back over the recording and see the slides, obviously. So they're going to be there till the end, and then we're going to do a live sort of work through of it in Teaching Week 5. You don't have to do anything to do with that question in the tutes. So it's purely a lecture, help you type thing that is just new this semester. The other thing I'd just please try to get you to do, I'm getting heaps, hundreds of emails, like I do most semesters. Some of the emails are obviously for me personally, so if you're having problems with content or you're having personal problems that you want to talk to me about, no issue. Use my t.thomas email address, which just comes to me and nobody else. But if it's a general inquiry, which I'm getting a lot of, so for instance, what questions do I do this week in the tute? Or what if I don't do 2 pages worth of work and it's only a page and a half? Will I get marked down? So if it's any of these general inquiries, can you please use the email that I put up on Blackboard there. So on the 25th of July, I posted an email which said I've set up this laws1100@uq.edu.au email, and if you have any general sort of stuff about the course, please email that. And the reason is a couple of my other teaching staff have access to that, and so can alleviate a little bit of my workload on responding to 1,000 plus students. My whole Monday, I think it was my Monday or maybe Tuesday, I lost track, one of the mornings for 4 hours, it was literally just me clearing emails from the course. So it takes up a lot of my time, and if I can get some of the more general inquiries sent to that one, that would be really, really good. Okay, so I think that's it for announcements. Don't think there's anything else. If I think of anything else, I will tell you about it after we have a little break halfway through. Okay, so ILAC. All right, so apart from the mid-semester, and apart from the multiple choice tests that you do there and the first tutorial, this is everything else in the course relates to this. So all the short answer questions and essay type questions have been taken out of the course that used to be in there, and I basically now just focus on your ability to be able to answer a legal problem, and that's what ILAC is. Some students who come to see me who did legal studies at school, some students who have studied law overseas maybe in a subject might know this method. It's sometimes called IRAC as well, I-R-A-C, but the principle is pretty much the same. It's more or less a method of answering problems. So it's structure, and it's the way that you can get your head around putting out a legal answer in a really structured, methodical type of way. It's used in all the other 2% tutorial work, so from Tut 2 onwards, all your 2%ers will be using ILAC. Practice exam questions, the ungraded problem set, the 20% problem set, the final exam questions, everything will be using this method. I find everyone by the end of the semester likes the method because it's structured and really easy to follow, and it kind of, I think, makes the law a bit easier to understand and less confusing. So it's a really good thing to get your head around early on in the course. What is it? Okay, you got 4 sections pretty much. And in an ILAC response, as you'll see when we get into it in the second tut, I actually want the headings. So I want to see in every response the word issue, the word law, the word application, the word conclusion, on its own line with an underline, and then what goes under that section goes under it. So in your final exam there should be 3 answers that look like that, and everyone's paper should start with the word issue, underline. The issue, it is short. So these are the things you should note down. Issue is short, it's always a question, and it always identifies the main legal area or problem. It's always around a sentence. So if I look at some of the things in this course, has Tim committed the tort of negligence towards Bob? That's an issue. Has Tim breached his contract with Bob? That's an issue. Has Tim breached any sections of the Consumer Law Act in his dealing with Bob? That's an issue. Has Tim infringed Bob's intellectual property rights? That's an issue. All of them a sentence, all of them short, all of them identifying the main area of law, and all of them with a question mark at the end. If I just flip to the conclusion, because the 2 are tied, if the issue is a short 1-sentence question, what do you think naturally the conclusion then should be? A short 1-sentence answer. Yep. So if you ask the question, you answer the question. Is Tim guilty of the tort of negligence towards Bob? Conclusion should be, yes, Tim is guilty of the tort of negligence towards Bob, or no, Tim is not guilty of the tort of negligence towards Bob. You don't put in any because. You don't say, Tim is guilty of the tort of negligence towards Bob because he has blah, 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 blah. Because all of that explanation should be above in the application section. The application section should give you all the rationale as to why you drew the conclusion that way. So that's the issue, that's the conclusion. What's in the law section? The law section is confined strictly to the law that you're using to prove your case. In the law section, I don't want to see Tim or Bob or the fact that the car was driven over someone's foot. There's nothing about the facts of the case in the law section. The law is simply legal principles, cases, legislation, and case analysis. So there's 4 potential things that can go in a law section. First one is legal principles, and that is just statements of law. As an example, the tort of negligence, you need to prove duty of care, breach of duty, causation. That's a legal principle. So legal principles, the first thing. Cases is the second thing. In almost every question that I'll ask you this semester, you'll probably have to cite a case or more. It seems a lot, but for a tort of negligence question, an answer of a 7, like a 7, a high distinction, would probably cite 7 or 8 cases by the end of it. Doesn't mean you have to go into depth about the cases, but you have to put a case name next to a legal principle, and you'll learn this throughout the semester. So legal principles, cases, similar to cases, legislation. So if it's come from actual acts or acts of parliament or statutes, legislation goes into the law section. And then the final thing, which I probably put a little more emphasis on than a lot of other people, but is the idea of case analysis. Now, what's case analysis? Case analysis is basically, we've learnt a case throughout the semester and you analyse it in your law section. And why do you analyse it in your law section? Probably because there's facts or an outcome or similarities to the question you've been given that you want to prove or disprove your point. So as an example, case analysis might be, in the law section, see Donoghue and Stevenson, in Donoghue and Stevenson, da 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 da, and you leave it at what the case was about. And when you get to your application, you then use those facts and use what you've said about the case to say yes, it's similar, or yes, or no, it's dissimilar, and what the outcome is. So really good case analysis might be, in this case, this happened. One of the cases we studied during the semester. Here in this question that Tim's given us, this happened. They're really similar because, and therefore my conclusion to the question is the same as the conclusion in the case that we studied. And that's all part of the common law and the legal system, because what did you learn last week with Anthony? In the legal system, if you have a court higher up and it makes a decision of the same type, the lower courts follow it. And this is this idea of the doctrine of precedent. And this is basically what case analysis is. If there's a big case we learn about and similar sort of things happen in an exam question, similar outcomes are probably going to occur. So that's basically what the law section is. Not every question will have case analysis, but you'll practice this in your tutorials this semester, and usually the rule of thumb is one of the final questions in the exam I base on a case. That's what I do. When you get to the end of the semester and the good students start practicing on past exam papers for the last 3 semesters that I've written the papers, you will see the obvious questions that are based on cases. And last semester, as I said to you, that it was so pleasing, the results, but 70% of students probably on that question where I based it on a case recognised that, did amazing case analysis and argued it really well in the application. So this is one of the skills. These are one of the skills hopefully you're going to get by the end. So recapping law section, legal principles, cases, legislation, case analysis, in brackets, if applicable. It isn't always applicable. Application section. Application section, if you've got a law section, the easiest way I say to students is, if here's my law section that looks like this, my application section here should just mirror image it. So I should literally be able to follow from the top of the law section down my application. And what I'm doing is using the law I've put in the law section against the facts of the case. So it's just using the facts in the question to argue the law one way or another. And that's the application. Issue short, law long, application long, conclusion short. So short, long, long, short. And more often than not, law and application are about the same length, I find, in student responses, to be roughly the same. Sometimes a question will differ, but more often than not, it's about the same. And I think that's about it for ILAC. So this is the method that we're going to use. And basically what we're getting you to do is produce this to any question that can be posed, any legal question. Why do I think this is a really good method? Because I think it's really like practice. Like if you are a lawyer and if you are looking at a question, the first thing you're going to think about is, what's the big issue? What do I have to prove here? Is it a negligence claim? Is it a contracts claim? Is it a breach of ACL legislation claim? And that's kind of what you do in the first section. And then you go away and you find all your law and you look up all your law and your cases and your legislation, and you get that, and then you apply your law to the facts of your client's case, and then you give them an outcome. And that's more or less what we're doing here. So it's really like what a professional would do, given a set of facts and given a question. So that's why I like it a lot. There's a little step-by-step there, which is sort of what it's all about. And as I said there, it pretty much replicates how lawyers and judges think. So a judge is exactly the same. A judge in deciding a decision in court would pretty much go through this process. Tutorial 2, so where does ILAC come into the course? Well, tutorial 2 onwards, everything's going to be ILAC method. The homework exercises that you do for 2% and the in-class exercises where you get the 40 minutes to prepare an answer, all of that uses ILAC. At the beginning of the week 5 lecture, as I said there to you, I'm going to go through the answer with you to the teaching week 3 question that I put up before. That's going to be using ILAC. The guide to the ILAC technique is found under course resources, so course help, that function on Blackboard, and that will help you a little bit with ILAC as well. I think by memory when I updated it this year, it's got a question, it's sort of got the things that you have to think of when you go through it, and I think it's a negligence question. So if you go there, that should be a good guide for you as well. There's a workshop later in the semester again that I do here, and I put up really good responses down to really poor responses from previous students in the course, so you get to see the sort of range of what students can come up with. And then the textbook. These are pages, as you'll see on the notes you've written, that I said to not look at for the mid-sem, but they're in chapter 4 and they do talk about the ILAC technique a little bit differently than how I teach it, but the theory is more or less the same. So you can go there as well. And that's pretty much ILAC. So any questions about this, you can come and see me. But I think by the end of the course, 95% of students know exactly what's required for this and are pretty comfortable using it. I don't think I marked an exam paper last semester. I think it was the first time ever where I didn't mark an exam paper that didn't use ILAC technique. So sometimes I've found students who never turn up, haven't done half their assessment items, just write in big lengthy paragraphs, word after word after word on the page. I don't think there was one exam paper I marked that had that. So I think everyone's getting into the swing of using this and seeing what we expect in the course. Okay, so that's that. All right. So first, I guess we could call it proper topic of law that we're going to study, which is negligence. As I said to you, it's tort law, and torts are more or less, as I say on the first slide there, it's an aggrieved person to sue a wrongdoer for the recovery of damages, pretty much. And a tort in Latin means just twisted or crooked, and it's a synonym for the word wrong. So a tort's pretty much a wrong done to someone else. It has a whole different range of areas that are covered by torts. So you have negligence. Next week we'll look at defamation quickly. Most of you would know what that is. Really important area called negligent misstatement. If you say something negligently, it's tied with some of the stuff we do this week, but it's a little area on its own. If you hit someone, that's a tort. So if you go up to someone, don't like them and whack them in the face, you've committed a tort against them. If you trespass on their land, it's a tort. There's a whole different range of things that we'll look at this week and next week. Usually compensation of the damages. So basically for a tort, you are being compensated for what has happened to you. So there's a recovery of damages or a recovery of money in most cases. Negligence, well, negligence isn't really about intent. I mean, if you go and you hit someone in the head, usually you've meant to. Negligence isn't that. Negligence is you haven't intended it. You've done it negligently. There's a degree of innocence, I guess, in what you've done, but usually that innocence comes with carelessness. So you've done something careless towards the other person. We learn it for a week and a half. Of course, it's by far the most common tort that happens. We see negligence claims all the time, and so it's a fairly important tort. And as I said to you, 95% of the time you'll be facing this in your final exam. You'll do it as the homework exercise for the second shoot. You'll do it again with me at the beginning of week 5. And by the time you've been through the answers for them and tried it a couple of times, most students are pretty comfortable with it. I think last semester we had about an 11.5 out of 15 average on the final exam for the negligence problem. So that was pretty good. I mean, 11.5 is a really good score. Okay, 3 areas. In every negligence claim, there are 3 steps you have to follow. After the 3 steps, you have to look at defences. Defences are really important with negligence. And then remedies at the end. And remedies just means what's the outcome going to be. The other thing you have to start thinking about, and this is what at the beginning of the course some students struggle with who start their summaries. You know, all this information here. Is this what I'm going to have to write? Is this what I'm going to have in my summary? A student came to me early this morning very quickly and said, here's my summary for the first week, what do you think? And it was very good, taken most of the lecture content, but some of this doesn't need to remain there necessarily. So something like this, as an example, this first slide, it tells you what a tort is, for sure, absolutely. But if you get a torts question, you get someone who's driven negligently and they run over someone else's foot, do you have to put this in the law section? Is it going to prove the case at all? Or are the elements below, the things you have to tick off and the requirements that have to be proven, going to be the stuff that proves your case? And these are the things that you really have to concentrate on in a tort of negligence question and putting it in the ILAC sort of response. So if you come to me with your notes, I can guide you along the way, but it's this sort of information that I do tell you about because it's important background knowledge, but you don't actually have to then go and put this in your summary notes if you don't want. And it's learning that art throughout the course of what's important and what's not that really will get the good notes at the end. We have 1 act, so a negligence question will require you to cite that, what's in red. I don't expect you to deal with a case that happened in New South Wales. Everything that you're going to get in your final exam is a Queensland-based question. So you don't have to look at other jurisdictions. And the jurisdictional, or the piece of legislation here, is the Civil Liability Act, 2003. In the slides coming up in the lecture, I state the act and the section when it's necessary for you to put it into an answer. So you'll see in further slides this restated, so I've got that all there for you. Okay, this here is really the start of what I would do for a law section on negligence. So if you're looking at preparing the tutorial 2 work in a couple of weeks' time, or you're looking at giving a go to the car question that I talked to you about for teaching week 5, the beginning of the lecture, this is where I would start with the law section. 3 steps for a negligence claim. Person commits the tort of negligence if they owe a duty of care, they breach the duty of care, and there's a causal element. So in other words, the breach of duty of care caused the harm that was done. For your little note to yourself, for your study purposes, requirement 3 there, the 3rd requirement, is the one that most students struggle more with. And a lot of the students who finish on 11.5 out of 15, still a good effort, really good mark, 10, 11, 12, usually nail number 1, nail number 2, and number 3 is not 100% wrong, but not 100% right. And unfortunately, number 3 is where you're working out what the person can actually get. I can claim the world. I can claim you hurt me and you owe me $1 billion. Doesn't mean I'm going to get $1 billion. And that's what number 3 is all about. So to make sure you really, if you want the 15 out of 15 for this question, number 3 is the thing you have to understand the most. And we'll be dealing with number 3 next week. So we'll be starting next week's class with the causation element, the 3rd element. Okay, from here, we're basically moving on to duty of care. So more or less the first step here. In saying that, Donoghue and Stevenson is a broader case for negligence than just duty of care, but it did focus on duty of care. Really famous, 1932, basically established the whole tort of negligence claim. Some of you will have or might be aware of the case. In modern terms, I'll give you the sort of rundown. You leave this class tonight, you go up to the refec, you want a drink. You go to the fridge, pull a drink out of the fridge, and a can of Coke. And the can of Coke, of course, you can't see into it. Coke's a dark substance. You don't really know what's inside it, except the dark liquid that you seem to be drinking. You drink it all, you get to the end of the can or end of the bottle, and there at the bottom of the bottle is the decayed, dead snail. The gooey mess at the bottom. You get very sick, and you have to work out whether you can sue someone for something. And this was more or less the situation that the courts were faced with in 1932 for Donoghue and Stevenson. It established the tort of negligence. They were the facts. So Mrs. Donoghue at a cafe, allegedly drinking ginger beer was the drink. The drink was, interestingly, and these are some of the facts that were fascinating about this case, the drink was bought by her friend, not her, and the remainder of the drink was poured out. This snail was in the bottle. It was not possible to detect it, and she suffered, as you see there, severe gastroenteritis and nervous shock as a result of drinking it, and it was a contaminated drink. There were two big issues here, because in 1932 this kind of situation hadn't been considered. And I think you'll understand what the issues were. Who was the contract between? If you have a simple contract, it was between the person who bought the drink and the shop owner, neither of whom actually really were a part of this problem, because the person who bought the drink didn't drink it and get sick. It was her friend that did. And the shop owner didn't make the drink. It was the manufacturer who made the drink. So the actual contract, the deal, was between two fairly unrelated parties in terms of the law. So the question was, could you sue them under contract? And at that stage it was really hard, because the contract wasn't between the two people that actually were involved in the problem. In the end, interestingly enough, it wasn't a unanimous decision, and you can see this in a couple of slides' time down the bottom. The majority, which was 3 judges, held something, and the other 2 dissented. So the other 2 actually said, well, because it wasn't a contract between the 2 people, that no claim could be made, and different arguments along those lines. So it wasn't a unanimous decision, it was 3-2. Fundamentally, the lady who got sick and drank the drink, Mrs. Donoghue, argued that as the manufacturer of the product, so the manufacturer of the product, who was Stevenson, owed her a duty of care as a consumer, meaning anyone who could possibly drink the item, to take care of them, that there were no noxious elements within the drink. So what she argued was there was this general duty, this principle that if I'm the manufacturer of a drink and I put a drink out there, anyone potentially who could end up drinking it, I owe a duty of care to, at law. I have to make sure that anyone who drinks it is safe with my product, even if they didn't buy it. And effectively, that was what was decided. So effectively, that argument won out. Lord Atkin was the main judge in the judgment, and he wrote really beautifully in terms of legal judgments. It was really lovely writing, and he got to the point and people could understand it. And he put in his part of the judgment, the question is whether the manufacture of an article of drink sold by him to a distributor, in other words, sold by him to the person who owned the cafe, in circumstances which prevented anyone from actually seeing the defect or seeing what was inside the bottle, is under any legal duty to the ultimate purchaser or consumer. So in other words, anyone who actually drinks the drink, that they should take reasonable care of them and provide that the item is safe. And that's pretty much what was held. Now, The facts of Donoghue and Stevenson, everything I've got there on the previous slides. Again, if you're looking at your summaries, for sure, put it in there. Have the facts there. Get what I've got in the slides and put it in the summaries. But it would be a very strange question in the exam to have to do case analysis there. Because if I, for instance, gave you an exam question where someone bought a birthday cake from the cheesecake shop and ate the birthday cake, and when they got halfway through there was a cockroach within the birthday cake, hopefully some of you might think to yourself, okay, similar to Donoghue and Stevenson, product, problem within the product, I can use case analysis, I can talk about the facts of Donoghue, talk about the facts of what this question is, compare them, give the same answer. Hopefully even at this early stage of the course you could see those similarities. But there are very few questions I'd ever asked on the final exam that are similar to Donoghue and Stevenson. What's important in Donoghue and Stevenson in almost every single negligence question is this slide. And what I've got there in blue is what I reckon on the last 4 examination papers in the final exam I like students to write. Because what this is basically the general principle of the duty of care. So Lord Atkin, in saying this, in saying his judgment there that I just wrote to you, developed this. And the neighbourhood principle is, you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. Who is my neighbour, he asks? Persons so closely and directly affected by my act that I thought reasonably to have them in contemplation. Now, what does that mean? It means that in his judgment, he's pretty much saying, if I'm a manufacturer of a product, anyone perceivably who could use my product, I should have in contemplation. So I owe a general duty of care to anyone in that situation. And that's basically the law that's been developed. If you put out a washing machine and it has faulty electrics and it blows up and it injures someone, you owe them a manufacturer's duty of care. And same with any item for use or consumption that we might be involved with that goes wrong. So the neighbour principle, Donoghue and Stevenson, and what's there in blue, really, if I was doing a negligence question, I'd be starting with this. Here are my 3 things that I have to look at. Then I'd be saying, first common law case was Donoghue and Stevenson, and from Donoghue and Stevenson, this established this neighbour principle. And that's really the start of a negligence problem. That's what I hope 900 students in the final exam give me at the start of the negligence problem. So you all kind of know where you're starting now with it. From this case, developed what's called established categories. And these are categories of people, of relationships, that automatically pretty much owe this. So in Donoghue and Stevenson's neighbour principle, when he's thinking about one person to another and one person owing a duty of care to another, these categories automatically establish that. You can see the first one on the list, the one I asked last semester in the final exam. Motorist, driver of a car, owes a duty of care to other road users. Person walking along who gets injured by his negligent driving. Instantly, duty of care is owed. Established category does that. It means the law goes, yep, driver of a car owes a duty to the pedestrian. Done. Move on. See if it's been breached. Doctors, patients, the same. Accountants, clients, bankers, clients. The 2 that you should highlight, put a little asterisk next to, manufacturers and occupiers. 80% of final exam questions would come from them. A manufacturer of a product owing a duty of care to another person using the product, or occupier of a premises owing a duty of care to someone else who enters their premises. And we go on about occupiers category a little bit more in about 5 minutes. That we've already covered. So you know about manufacturers, and you can often get hypothetical scenarios in the final exam that talk about that, manufacturers category. And then occupiers. Occupier of a premises owes a duty of care to all persons entering the premises to ensure that the premises is safe. You should highlight and just take note of ensure the premises is safe. And I will give you a scenario in a minute that proves why I think that's important. Australian Safeway stores in Zaluzna there. Case. Now you'll see here an example of a case that I've got in the PowerPoint slides, but I've got nothing about the case. I've got no facts. Sometimes, like with Donoghue, I might put facts for you. Sometimes, like with Australian Safeways, I don't. For the purpose of your summary notes, if I go over the facts with you in class, if you're doing good summary notes, you should then go to the textbook, summarise the little box, and if you've seen the textbook, it's in green. And if I've gone over the facts in class, summarise it down, make it short, and put a sentence or two on each case. Take that into the exam with you. There'll be stacks of cases throughout the semester, like, say, this one, where I might not go over the facts and I might just move on. In other words, occupier owes a duty of care to people on their premises to ensure it's safe. All you have to know about that case is that's the case where that principle came from. Don't have to know anything about the facts. So think about that. If I was you, I'd have a highlighter or a little asterisk, and the cases that I do go over with you, put the asterisk and then go and do a bit of research in your own time. The cases where I just have them there and move on, you don't have to worry about for the final exam. The only cases in the final exam and throughout the course where you will have to know about the facts of them for potential case analysis are the ones we go over in class, not the ones that are in the slides that we haven't been over the facts in the lectures. Okay? Australian Safeway stores is one which you can just quickly give a summary to in your own time from the book. Old lady walks into a supermarket, pool of water has built up on the floor, old lady doesn't see it, this is Zaluzna, falls over on the floor, hurts herself, sues for an occupier's duty of care. Premises, the supermarket isn't safe because it has a slippery floor. Supermarket knew about it, supermarket didn't do anything about it. What should they have done? Probably put a sign up saying caution wet floor, or they should have put an attendant there with a mop where every 15 minutes they mopped up the floor, but they didn't. Premises wasn't safe. So that's just an easy classic example of the Australian Safeway and Zaluzna occupiers category. Note to yourself, put a little note off to the side. This slide, slide 15, does it extend to people not on your premises that aren't there with your permission? You don't have to know this for the final exam. You don't have to know this for any part of the course. I'm just bringing it to your attention to teach you the principle. So slide 15 there, when you're doing it in your summary notes, put a little note there saying you don't have to take this into your summary notes with you. It confuses a lot of students. When I told students on Monday about it, there was sort of murmur amongst everyone because they didn't get it. Hackshaw and Shaw, interesting case on a farm. Fuel kept being, and this again, you don't have to, I'll tell you if it's not necessary, you don't have to go and learn this case, but for your own benefit, fuel on a farm kept being stolen. Farmer went out one night with his gun, laid in wait for whoever was stealing it, car drove up, person got out of the driver's seat, started stealing the fuel again. Farmer shot his gun at the car, hit the car. What he didn't know is there was a passenger in the car. Injured the passenger in the car. Question for the court was, did he owe a duty of care not to shoot that gun at the car to ensure his property was safe, his premises was safe? And in actual fact, the court found that he owed a duty of care and he was actually negligent towards the passenger. even though they were illegally on his property. Interesting one. If you think about the logic behind this, and we go back to this, and we take away the fact that they're illegally on the property, and we think of the neighbourhood principle, think of what this is. Car drives up, it's night time. What do you think about cars? Well, usually they're full of people. So if you can't see what's in the car, as a neighbour, taking reasonable responsibility for your neighbour, people who can potentially be there, if you were being reasonable, would you fire a bullet into a car not knowing if anyone's in it? The answer is probably no, and that's why a duty of care was established. So that's the logic behind that. Whether you agree with it or not as a matter of principle, because they shouldn't have been there in the first place, is another thing. There's been some really interesting cases on this in the US that I've seen over the years. I don't know if their legislation's changed, but I remember reading one once where the person had climbed to the roof of the house, so they were an intruder, climbed to the roof of a house, trying to get in, fell through at night time, fell through the sun roof, so the glass area on the roof, fell inside the house onto a bench, a kitchen bench, where there was an unprotected, an unsheathed knife, and the knife went through their leg, and the person actually successfully sued the homeowner for having fallen through the roof of their property onto their bench, and because there was an unprotected knife there, they established a duty of care and got compensation for that. Now, it doesn't mean the other way around, the homeowner wouldn't be able to claim trespass and a whole lot of different things, but technically still, there's an occupier's duty of care. So it's a really interesting, strange area of law, but just realise that this one here, not assessable on your final. Before we get here, I want to point out something. So, scenario, real life. So this is a potential question that you could say get in your examination, and you have to think about how you'd argue this. Restaurant. Group of your family going to a restaurant. You've been there before. You like this restaurant. You all go for your grandfather's 90th birthday party. And you walk into the restaurant, you sit down, and as part of the restaurant, part of the entertainment, the owner of the restaurant, who's a 30-year-old young woman, belly dances for all the patrons. And she has a little stage there in her restaurant. It's like a Brazilian barbecue type thing with entertainment while you eat. She does her dancing. She knows it's your grandfather's 90th birthday. And so she goes to him and she starts saying to him, please come up, enjoy the fun with me, try to dance, it's your birthday, have a good time. He says no, no, no. She says yes, yes, yes. Eventually, after a whole lot of compelling, he begrudgingly goes up. The stage is there. He rigorously tries to keep up with her dancing, and he breaks his hip in the process. Does she owe him a duty of care? He's on her premises. Is it an occupier's category? What's the problem with it being an occupier's category according to the words on the screen? Anyone astute try to pick it up? Come on, someone try. Absolutely, it's got to do with the safety issue. Is there anything actually wrong with the premises? How was his injury caused? His injury is caused because he's 90 and he tried to keep up with this physical activity with this 30-year-old professional belly dancer. So what's wrong with the premises? So how can you establish an occupier's category there? And what we eventually learn, which we do in a couple of slides' time, is down here. What if it doesn't fit into a category? If it doesn't fit into one of those Donahue and Stevenson type things, motorists, doctors, manufacturers, occupiers. And down further, There's a way of looking at that, and that is the non-established categories and the tests we look at there. And that belly dancer example is exactly that. Nothing wrong with the premises, so we have to look beyond the occupiers category and beyond the established categories of duty of care and test it on a original basis, on its actual facts of the question. We'll get to that in a couple of slides' time, but that's to get you thinking about that scenario with the belly dancer, and it's a good one to think of in terms of whether or not an established category fits. Part of the occupiers category is a separate little issue of public authorities. So we move away from private residents, so your private residents having to make sure it's safe, to public areas. What happens if you go to the beach? What happens if you're swimming between the flags and something goes wrong? What happens if you're out bushwalking? A question that I've set previously in a past exam. You're out on a mountain path, it's obviously well cared for, obviously the local city council looks after it, something goes wrong. Does the city council or the public governing body owe you a duty of care? There's a lot of writing there. The thing that you should highlight is basically that. Does there exist a duty of care to warn of what they call hidden risks? Ask yourself, is there a hidden risk that requires warning or prevention? Or is the risk so foreseeable or obvious that a reasonable person would know about it? It's basically all case law. This one here, Nagel and Rottnest, is what the final exam paper from, I think if you look back to 2018, semester 1 or 2, the negligence problem was pretty much based on this. And if you look at case analysis, what I was talking to you about before, this was one of the ones I pulled out. The actual case that occurred in 1993 was about a water hole. There was a big submerged rock in the water hole, no one could see it. It was a very well maintained sort of picnic swimming area. The local council had put up a big sign saying swimming area, safe to swim in. Young people came across this, went up to the rock, dived in, dived onto the submerged rock, got hurt. Question was the local council liable for that? If you go back to the previous slide, ask yourself the question, was there a hidden risk that they should have warned about? In the facts basically said the local council knew about the rocks, hadn't done anything about it. The sign saying safe swimming zone had encouraged people to swim there, and therefore, yes, in this case, there was a duty of care owed on behalf of the council. 3 semesters ago, if you were a student in Laws 1100, I stood here in the lecture, I said, really important case, guys, should know about it. They got to the end of their final exam. There on the final exam is this question about Cairns up in North Queensland. Group of friends go walking along a mountain path, come to an outback billabong swimming area, and instead of a submerged rock, it's a submerged log. There's a big, fairly easy rock ledge that you can climb up and jump off. The student did that. 10 metres down, fell onto the submerged log. What's the case? And that was their final exam question. So you can start, I'll do this throughout the semester, you can start to see the types of questions you're going to get. By the end of this lecture and next week, you should literally have been able to answer that question. Same sorts of things applied. Donoghue and Stevenson, occupiers, public authority, Cairns Shire Council, did they owe a duty? Yes, there was a hidden risk. Last slide, duty of care owed. Case analysis in the law section of Nagel and Rottnest talked about the facts, and when it came to the application, used those facts, compared it to the question, and gave an outcome. Again, very good grades on that type of question because students were aware of it and had done their prep work for it. Similar sort of one, Swain and Waverley, beach. Go down to the Gold Coast, there are the flags. Most of you who've swum in the surf, if they're big waves, you dive into it. because otherwise you get knocked over, so you dive into the wave. It's between the flags, person dives into the wave, sandbar. Dives straight into the sandbar. Is there a duty of care? In this case, again, yes, duty of care owed. Between the flags suggests you can go out there, suggests that you can do surfing and all those activities, and a duty of care is a hidden risk. Hidden risk was warn us of the sandbar, tell us not to dive into the waves. So on your notes you can put yes, duty of care owed there, yes, duty of care owed there. So both of those cases a duty of care was owed. The next two, no duty of care owed. So you can put down for slide 20 and 21, Romeo and Conservation Commission, and Vary and Wyong Shire Council, no duty of care. Really silly case, this one, what their argument was. Unfenced public area on a cliff. So think about if you've ever been to a place, the Great Ocean Road is an example in Australia, where you're driving along a road and you literally have a little bit of ground and then it drops off into the ocean and there's no fence or barrier there. This person gets out, walks to the edge, right to the edge, you're talking about like here, and the rocks give way under their feet and they go falling down and get fairly injured. And they argued that there was a hidden risk there that the local council should have warned about. And think about it's the stupidity of that argument. You've got a big long stretch of ocean road and you're suggesting that the local council, maybe every 5 metres, should put a sign saying don't go too close, don't go too close, don't go too close. It's a fairly silly argument, that. If you look back to this again, that's where that kicks in. Is the risk so foreseeable or obvious that a reasonable person wouldn't think that a duty of care should be owed? And a reasonable person, probably, hopefully most of us, wouldn't go too close to the edge because we could be afraid that the rocks might come away and we could fall down. So you shouldn't have to warn of that. Same thing with the last one. Difference between this case, coastline, ocean, and this case. In this case, flags, patrolled, beaches, saying people should go there. In this case, rugged, natural part of the ocean. You know, headland like this with rocks. Person goes to the headland, dives off the rocks, again, structures underneath that they couldn't see and they get hurt. Difference between these cases is the City Council has control over those areas and gives signs and flags to let you know it's safe. In this case, no signs or flags. So in this case, it's simply a matter of it's at your own risk if you want to do that, and no duty of care is owed if something goes wrong. So they're the 4 cases for public authority. We now move on to no established categories. Remember back to the belly dancer example. We've looked at the restaurant, nothing's wrong with the restaurant. Old man wants to work out whether he can sue the owner for what happened. There's no category that he can go under, so these are the requirements here. 2 tests. First test, Donoghue and Stevenson neighbourhood principle. Exactly what we looked at before. Is it reasonably foreseeable that a person in the defendant's conduct could cause harm to the plaintiff? So in other words, think about the belly dancer case. Is it reasonably foreseeable that the belly dancer could cause harm to someone in the 90-year-old man's situation? Is it reasonable that the belly dancer performing her acts with him could cause him injury? The second one, which students struggle with a little more, is what's known as salient features. Are the salient features of the case consistent with the establishment of a duty of care? Now, what do salient features mean? Salient features just mean aspects of the case that might favour duty of care or not. And there's no exhaustive list of what salient features are, but on the next slide, these are a list of the types of things that can be included. So, relationship between the parties. Control, who has the control. Knowledge, who has more knowledge than the other party. Experience, who's experienced in the activity. Vulnerability, reliance, and a really interesting one, personal responsibility. So think about how you'd argue this in court. You're a 90-year-old man. She's a 30-year-old professional belly dancer. She's coerced you to come up. You've said no, no, no. She's kept pressuring, and in the end you do it. Let's have a look at these factors. If you look at the first test, is it reasonably foreseeable that the 30-year-old belly dancer's conduct, by getting him to go up and rigorously dance with her, could potentially cause the 90-year-old man a problem? And I think the answer safely would probably be, yes, it's reasonably foreseeable that that might occur. And then we get to all these. Relationship. It's important whether they knew each other. And this, I'm not saying that these are the sorts of things in the final exam, but in a practical scenario with that belly dancer example, did they know each other or didn't they? Did she know that 2 weeks prior he'd had a hip replacement? Did she know that he was a really fit 90-year-old guy who at the age of 90 had been on the news 2 months ago for competing in a triathlon? Are these sorts of things known by the parties or not? And these are the sorts of facts which could weigh up either side. Control, probably her. She was in a position there where she owned the restaurant, his birthday, she coerced him. She probably had the dominant position of control. She definitely had the dominant relative knowledge. She was the belly dancer. She was the one who knew physical capabilities of people in that sort of activity. Experience, same sort of thing, would favour the fact she should give a duty of care because she's the one with the knowledge of it. Vulnerability, he's probably more vulnerable. He's relying upon her more because it's his birthday and he doesn't know the activity as well as she does. Most of those first 5 areas would probably persuade a judge to think a duty of care was owed. As the professional belly dancer, 30 years of age, she owed a duty of care to ensure the 90-year-old man was safe. Duty of care to ensure he was okay. And then we get to the last point, really interesting one, personal responsibility. As a practical scenario, you can put in your notes, courts really take this into consideration. Personal responsibility is one of the ones that the courts really will weigh up quite heavily. Nothing in these facts says that she was holding a gun to his head saying, dance. Yep, nothing. He could have literally stood back and gone, look, I'm just not up to it. My health's not good enough. Personal responsibility massively favours lack of duty of care. So massively favours the fact that he's a grown 90-year-old man and he could have just said no. There was no one too much pressuring him into it. He could have just gone, can't do it. This is the interesting part about the law, and it's why I give you that scenario of the belly dancer early on in the course, week 3 when we've just got into this ILAC stuff. Because if I gave you that exact same scenario in the exam and I asked you to argue it as to whether there's been negligence, there are 2 really compelling arguments. You would have the one side for her saying personal responsibility means no duty of care, I'm not liable. And you'd have the other side for him saying relationship, control, knowledge, experience, vulnerability, yes, absolutely, there's a duty of care. Who knows what the answer would be? It'd be up to a court to determine that. And this is the thing about the law, and it's what I said to you in week 1. I don't really care how you argued that in the exam, so long as you argued it well, so long as you gave your backup and you said, these are my reasons. And probably in a scenario like that, by the end of the semester, after 13 weeks of teaching you, the tutorial syllabus that I've got with the type of questions I've got in there, I'd like you to be able to say, here are the two sides. Here's the one side that favours duty of care, here's the other side that doesn't. In the end, this is the one I think that's better. And that's a really good legal response, because that's weighing up all the different options and then giving your opinion in the application section. And that's what really highly advanced students can do in the end. We teach you that throughout the tutes. I try to give you questions like that. The one thing I would say to you is always be smart about exam questions. If I set you a question like that, do you think 15 marks would be allocated for just saying there's no duty of care done and not going on to breach and causation and the different elements? Probably not. So even if you found no duty of care in an exam question, what I would say is, even though I think no duty of care would exist because of the personal responsibility that should have been put on the old guy, he should have known better, she shouldn't have owed him a duty of care because he took it on himself and it's his fault, I'd still go, if that isn't the case, here's my application for breach and causation and show those other steps through. So it's just safeguarding yourself and giving yourself a full answer and opportunity to kind of get the full 15 marks. We go on to breach next. I'm going to give you this is almost to the minute that I was at on Monday as well, couple of minutes break. What I will do is make this easy for you in terms of your notes for duty of care. There are pretty much 3 options for an exam question. You know you're going to get negligence. What I can tell you now is breach, which we do in the second half today, causation that we do next week, and defences that we do next week never change. The law is the same for every question, regardless of the duty of care that's established. So everything else, your summary notes pretty much gives you word for word, and 900 students in this course for breach, causation and the rest should write the same thing if they're doing it really well. Duty of care is the one thing you have to think about. So if you want to put in your notes, put this, because this is the process I'd be going through. In any negligence question, first ask yourself and get rid of the question of, is it a public authority? So your first thing I'd be doing in an exam question is going, is this a public authority? In 85% of questions, you'll go, no, it's not. It's between 2 private individuals. So I can get rid of, in my notes in the exam, get rid of having to think about these cases, because it's not relevant, it's not a public authority. After you deal with public authority and you say yes or no, if it's a yes, you go to this slide in these cases, say whether there's a duty of care or not. If it's a no, second question is it an established category? So question number 2 is it an established category? And you go to slide 12, you look down that slide and you say, does it fit within one of these things? If it does, your life is so easy, because you're literally saying, Donoghue and Stevenson, neighbourhood principal, doctor owes a duty of care to their patients, done. Duty of care established, on to breach, like we're going to do in the second half today. Third question, if it's not one of these established categories, apply these 2 tests and then see whether it's a duty of care that's been owed. So 1, public authority. 2, does it fall within an established category, which makes your life really easy? 3, if it doesn't, does it fit these 2 requirements? And that's kind of duty of care in a nutshell. And it's the only thing you really have to think about in a final exam on this question, because everything else, you follow the slides and you follow the requirements and it's laid out for you, and you should be the same for every question. Okay, 5:24, round about 5:30, come back. Breach of duty is nice and short. Got some nice points for you and some key points that I'll tell you the slides that you'd put into your exam question, and we'll go through them with the cases, and it's a nice, easy last 20 minutes of the class. If you have any questions, come on up during the 6-minute break. If not, go and have a drink, bathroom, whatever you need to do. and we'll start back at 5:30. How are you? That's what I was talking to you about at the beginning of class. I mean,
Yeah, because I've been a bit sick, so I've still got all the notes, but I've done like a lot more papers than two, so I'm just like kind of getting down with all the cases and stuff like that.
yeah, I mean, we need to send the note in.
Yeah.
So, I mean, I have maybe Thursday cohort in something like for the first couple of weeks. I have got 2/3 cohort in something as well.
Yeah. Like for the thing that you get marked like that someone knows.
No, they're just the responses to
Okay.
So your
I thought
summary
that was
notes
something
is,
else.
your summary notes is what I suggest we run against. So if you come to my office at any point, I'll show you. But what I've done, what I started to develop is basically the whole course into one sentence. So instead of having a textbook exercise, computer science, electronics, choose maths and other things like that, all of that goes in one. And that's what the summary document
Yeah.
is.
Where do we find to do the things with the first tutorial thing, the questions for that?
Teaching has 3 tubes folder. So if you click on Learn, this is teaching has 3, Okay, 5:30, good. All right, so this is a nice, simple little section, probably won't even take the 20 minutes. Different to duty of care, it never changes. So every single question that you get on this in the final exam will use exactly the same breach of duty requirements, regardless of whether it's the belly dancer, Donahue and Stevenson, Nagel and Rottnest with the submerged rock. Any question on negligence will be the same for breach of duty, and you go through the same process and the same questions. So once you've established duty of care, you go on to breach. So this slide isn't really necessary for your summary notes. It's more just giving you an idea of what it is. It's this slide in particular that is very necessary. This is where the Civil Liability Act kicks in for the first time. So remember at the beginning, the different acts, the one in red that I had right up the top, and I said Queensland Civil Liability Act. This is where it is. I literally, in the final exam for a negligence question, would like to see that. Just like it is there. Your one option to shorten it is this, and this isn't really all that necessary. Now what you'll see, this is an interesting point about the summary notes, with the girl that did it previously, and I've got her example up in my office, word for word she put what was on the slide here, but then she did this. Oh, I can't do it on this machine. The cross through, the strike through, where you put a line through the middle of your work. She did it for everything I've got highlighted there. So what that means, and I get students who come up and look at the summary notes in my office and say, why is all this crossed out? Jackie went to the extent of working out what she would write in the response, so working out that her answer in the final exam would be breach of duty of care comes from Section 9(1, Civil Liability Act. 1, was the risk foreseeable, reasonably foreseeable? 2, was the risk not insignificant? 3, what would a reasonable person do? So she cut out all the descriptive stuff and she kept the actual requirements. And the reason why she said she did that to me was, if she's in the exam, she has a mind blank, she doesn't remember what one of these things means, the descriptive stuff underneath, even though it's crossed out, she can still read it and see it, and she can jig her memory on what it is. Very, very smart way of doing it, because it's basically just maximising your available time, because you're taking out all unnecessary thinking that you would otherwise have to do in the final exam. So it's a very, very bright method. You can see that if you come and have a look at what she did. In the breach of duty section, you have these 3 general questions, and then to answer the third one, if you skip down 2 slides in your notes to slide 27, there are 4 elements that you have to consider in relation to what a reasonable person would do. So basically the courts go, all right, was the risk reasonably foreseeable, yes or no, and why? Was the risk not insignificant, yes or no, and why? And then in this circumstance, what would a reasonable person do? Well, to figure out what a reasonable person would do, in other words, whether they breached their duty, we'll consider from Section 9(2) of the Civil Liability Act, probability of harm, likely seriousness of harm, burden of taking precautions, and the social utility of the defendant's activity. So it's basically 3 questions and 4 things, one after the other, and that's your breach of duty section in the law. You can have it totally pre-prepared, totally in your summary notes, ready to just write out in your final exam and have it ready to roll. The one thing I would say to you also is each of these points on the board, what a reasonable person would do, there's a case to go with it. Probability of harm, Bolton and Stone. Likely seriousness, Paris-Stepney Borough. Burden of taking precautions, also Bolton and Stone. And social utility, Watton, Hertfordshire. in the exam, and you'll see this in the church, you'll see this in the practice, the one in teaching week 5 that I show you here. I just like seeing students say probability of harm, C, Bolton and Stone. Likely seriousness of harm, C, Paris-Stepney-Borough. And these are really good example of cases that you don't have to go into the facts of them, you just have to state them in your exam because they're the glue that's holding it all together. You know, if you go to court, the judge will say, well, where did you get this legal principle from? How do I know what probability of harm is? And the lawyer will say, well, Bolton and Stone is the case for that. You don't have to know the facts, you have to give the authority. And that's kind of how it works. And you'll get heaps of examples of how this is set up as we go along. What do these questions mean? Risk was reasonably foreseeable. Well, if you've established a duty of care, then your first question is, the risk from the point of view of the defendant, was it reasonably foreseeable? So from the point of view of the person manufacturing the ginger beer, is it reasonably foreseeable that if a bug, a snail, is in the bottom and someone drinks it, there could be injury? The answer, of course, is yes. Was the risk not insignificant? You can think of this also as, is it a significant risk? If someone digests a decayed snail, is there a significant risk that they might, have harm done to them? Well, yes, of course. If you're not watching where you're going, where you're driving, is there a significant risk that someone could be injured? Yes, of course. You might kill them. Of course it could be a significant risk. So these are the sorts of questions you're answering in the exam. It's never too much. It's a sentence. It's just applying it to the facts. Yes, getting him up on stage as a 90-year-old man with strenuous physical activity might cause a significant risk, could cause him a heart attack, could cause him a hip problem. So all of these sort of things are just the general application of facts that you're doing in a question. The law becomes much easier once you study it. It's just a case of requirements and going through the requirements, asking the question, looking at the facts and applying the facts to the question. And that's basically what happens in court. That's the role of a lawyer. And that's at the end of the semester, hopefully, what you guys are all going to be able to do. You then get to the third question. What would a reasonable person do? Reasonable person, you don't have to put this into your summary notes, but again, it's good background knowledge for you to think about. Reasonable person is someone of normal intelligence, credited with perception of the surrounding circumstances that a relevant normal person would possess. So you're not talking about someone particularly bright, you're not talking about someone particularly stupid, it's just the normal average person thinking about the normal average thing in the normal average way. Throughout the whole course, in almost every topic that we do this semester, you're going to hear this a lot, because the general legal stance or standard in most of the tests is that of a reasonable person. So in a lot of the areas of law, this is going to be relevant to the stuff we study. Okay, so to think of what a reasonable person would do. Basically, if the courts say, well, a reasonable person wouldn't have gone to that extent. So a reasonable person wouldn't have ensured that the contents of their ginger beer was free from a snail because of whatever reason, then they haven't breached their duty. And of course, in that case, that wouldn't be the case, but that's the test that you're going to say. Really good case for this is Bolton and Stone. It's a really good case to understand, and definitely one to put the facts down in your notes for. Definitely one that you can potentially have good case analysis in a final exam. Bolton and Stone, cricket case. Cricket stadium. Player in the middle smashes the cricket ball. Cricket ball clears the stadium. Hits someone on the outside. Is it negligence? Did they owe them a duty of care? Did they breach their duty? There were two things in particular. So two of these issues for breach of duty are what Bolton and Stone looked at. Probability of harm, and the third one, burden of taking precautions. Now, a couple of facts with Bolton and Stone that aren't there in the slides, but might be relevant enough for you to write down. In the 30-year history of the club, so a very long history of the club, a cricket ball had only cleared the stadium 12 times. So in the whole 30-year history, a cricket ball had only gone over 12 times. And when it had gone over, it had never hit anyone and never caused injury. So again, the reasonable person, what the courts say, looks at the probability of harm. Is it a high probability that harm would occur, or is it a very low probability that harm would occur? In 30 years of the stadium, has harm ever occurred? No. So is it high or is it low? Very low. So in Bolton and Stone, the question is, with such a low probability of harm, would a reasonable person have done anything to try to stop it? In other words, do you raise the stadium to a point where a cricket ball can't go over it? And the answer in that circumstance is no, a reasonable person wouldn't do that. So the low probability of harm in Bolton and Stone favours the fact that a breach of duty didn't exist. If we contrast and we skip requirement 2, and while we're on this thought, go to requirement 3, burden of taking precaution. In Bolton and Stone, the probability of harm, as we just said, was really, really low. In Bolton and Stone, the burden of taking precautions was 1, really costly to raise the whole stadium to ensure a ball never cleared it, and 2, really time poor. So it would have taken a long time and a lot of inconvenience to the stadium and the sport that occurred in the stadium to ensure that the stadium was raised to a point where a ball didn't clear it. So, low probability of harm, high burden of taking precautions. A reasonable person in that case definitely wouldn't have taken precautions to avoid or to breach the duty, to ensure that it didn't occur. So these are the types of things a court will consider in looking at whether a reasonable person, what they should have done. Clever students. So this is, I always say, if you're wanting to pitch at that 6 or 7, you're sitting there and you're going, I want my GPA high, I like the idea of this course, I want to get a 6 or a 7 in it. This is the sort of area you can be very clever in, because any question really can have a case analysis of Bolton and Stone, because in any question you're going to be able to look at the probability of harm and the burden of taking precautions. You can contrast it. So as an example, if I was sitting there last semester in that final exam with the car case, in the law section I would put, in Bolton and Stone the probability of harm occurring was very low, because in the 30-year history of the club, a ball had only cleared the fence 12 times and had never hit anyone. So probability of harm really low. Compared in that case to the burden of taking precautions, which because of time and cost was really high. Therefore, a reasonable person wouldn't have been said to breach their duty if they hadn't raised the stadium to a point of no ball being able to go over it. So can everyone kind of follow that logic? In any case that you're given in an exam, you can either say it's the same or say it's different. Is it a high probability of harm or a low probability of harm? Is it a high burden of taking precautions or a low burden of taking precautions? And in the application section, you can just do an application there. In Bolton and Stone, we heard this is what happened, low probability, high burden. Here, because of these facts, this is what happened. Also low probability and also high burden, and therefore no breach of duty. Or, in this case, high probability of harm, low burden of taking precautions, outcome will be different from that in Bolton and Stone. And that really is your first example of a really good case analysis. Something where your examiner, whoever's marking your paper, will be going, this student really does get it. That's really good application of the law and really good application of cases. So that's an option there for you guys to think about. Try it with your second tutorial problem. It is very obvious and very easy which way it is, and you can try a case analysis there with Bolton and Sohn to see how you go with writing it. And in your tutes, we focus on that. I put a little note to the tutors to look at that with you and give you this spiel once again. Likely seriousness of harm. This is not a case I would ever do a case analysis for, really, but it's a very strange case, but it gives you this warped kind of extended idea of what likely seriousness means. It means, is it minor or is it serious? And this is something to take into account when thinking about what a reasonable person would do. If the harm's only minor, a reasonable person should be less inclined to try to stop it. If it's major harm that could occur, a reasonable person should go beyond to try to stop it from occurring. Paris Stepney Borough Council, really quickly, as you can see there on the board, guy welding, using the equipment. In this case, he only had one eye, so he was a welder with only one eye. The company he was working for didn't force him to wear eyewear, so he said he didn't want to and they didn't pursue it. And as he was welding, the spark came up and hit the other eye. So he went from one eye to 0 eyes, totally blind. The courts, in their judgment, actually said because he began with one eye, the likely seriousness of harm in him losing a second eye is really high and much higher than a person that had 2 eyes usable to begin with, if you can get that logic. It's a hard one to get your head round, but you sort of work it out when you think about it. So in other words, is it more serious if you have no sight or if you have partial sight? And I guess that's the question they were looking at. I'd never ever said a question where you had to do case analysis of that, and you wouldn't even really need to put the facts of that case in your answer. Just remember the severity of the damage, the severity of the harm is what they look at to determine what a reasonable person may or may not do. Final one, and this is last slide before we head off. Social utility. The note here, and you should all write this down, because every semester I get stacks of students saying, what on earth is social utility after the lectures and in the tutes, because they don't understand it properly. I can't remember a question I have set in the final exam where social utility is actually applicable. So what you can write off to the side here is, in very limited circumstances do I have to actually apply this. Very limited. And in most cases, what I expect of students, and in 90% of the student answers last semester, probably even more, they literally wrote in the application section, social utility not relevant. Not a relevant argument. So you still put it in your law, because it's still one of the requirements of breach of duty, but when it gets to application and when it gets to applying it to the facts, you just say not relevant, not necessary. Social utility argument is when there is a social benefit to what is happening. So the big thing here is emergency services. If you're an emergency service worker and your job is to benefit the greater good, so if you're a fireman or a police officer or an ambulance officer, your social good is helping the community. You're there to serve a purpose, to help others, to help us as a whole. And that's what social utility means. And what the courts look at is, if there's some situation where the negligent act occurred, but it occurred doing something that had a social benefit, then that can be weighed up in terms of what a reasonable person would do. In the Watt and Hertfordshire Council, fireman was called to an accident. There was a particular car that was needed to transport a piece of machinery to the accident that was necessary to get someone out from a car accident. The car wasn't there at the station, so the fireman took another car that couldn't secure the machinery properly, and the machinery moved during the trip and injured the fireman. And the question was, as part of his duty, as part of his job description, which is helping people and you know you're going to take risks, was the risk of putting the machinery in a car that didn't have it secure something that had social benefit? And of course the answer there was yes, it was. So that affected what a reasonable person would do in that situation. Again, it's not a case I would transfer facts to your summary notes and bother with that. It would be highly unlikely. I can guarantee you I wouldn't have a question in the final exam that had something necessary with that sort of an argument in it. So really, out of all those cases to do with breach of duty, it's that Bolton and Stone one that you should concentrate on. And try to use and try to argue in your tutorial work in a couple of weeks' time. As you can see, same for everything. Makes your job easy with the final exam. Every student should have the same stuff, same requirements, same cases, and you can prepare that section of your answer pretty well. Okay, I will see you either in Tutes or next week.
Why would you have a lecture? No one is going to be watching the lecture.